Hello my dear learners, a very good evening everyone. I am Shashank and I welcome you all on English Medium Prep by Exampur, which is a complete English medium YouTube channel. So students, very good evening everyone and welcome to the session, and please confirm your attendance. Then we are going to start today's discussion, and today we are going to discuss the judicial system of India part 2. So topic of today's discussion will be the judicial system of India part 2. We are going to discuss for the today's session. So Sharvani, very good evening and welcome to the session. Good evening and welcome to the session. And students, the session of evening, they are completely dedicated to SSC CGL examination. So keeping in mind the level of SSC CGL, especially for tier 1 and tier 2, we have designed the session of evening. So session of evening, it is exclusively designed for tier 1 and tier 2, keeping in mind tier 1 exam and tier 2 examinations. So that is Indian judicial system part 2 we will be discussing. In the last session we have discussed the judicial system part 1, that was on Friday. So students, let's begin the session, that is judicial system of India part 2. Let's begin the session of today. Let's start the session. And here is the first question that is before you. Ki acting Chief Justice of the Supreme Court in India is appointed by whom? So good evening Mr. Putin, student prepare. Good evening Vikramaditya, good evening. So good evening guys and welcome to the session. Welcome to the session everyone. So first of all, the acting Chief Justice of the Supreme Court in India is appointed by whom? So who appoints the acting Chief Justice of Supreme Court? Is it Chief Justice of the Supreme Court himself, Prime Minister, President or Law Minister? So who appoints the acting Chief Justice? Okay, Sharvani, you are saying C, then everyone is going with the same option, that is option C, option C, option C. So first of all, acting Chief Justice. Acting Chief Justice, it simply means temporary Chief Justice. Temporary Chief Justice is appointed by whom? So temporary Chief Justice is appointed by President of India. And when President of India appoints acting Chief Justice, and he is appointed in three conditions. First is when the post of Chief Justice is vacant, and vacancy arises in three conditions. First condition is if the Chief Justice has died or Chief Justice is removed. Chief Justice is removed, or Chief Justice has given the resignation, and if Chief Justice is outside India. So President of India appoints the acting Chief Justice. Reason is this, ki acting Chief Justice or the temporary Chief Justice is also the executive head of Supreme Court. So Chief Justice is executive head of the Supreme Court. That means ki whatever the things that is did, that is being did by the Chief Justice, that is also related to the executive works of Chief Justice. For example, creating the benches of the judges, seeing if the judges, the sanctioning the holidays of the judges or sanctioning the leave policy of the judges, that is all did by the Chief Justice. Therefore, the post of Chief Justice cannot be left vacant. Therefore, whenever there is a vacancy in these three conditions, President of India appoints the acting Chief Justice, that means the temporary Chief Justice. So correct answer will be option C. Please fetch the questions related to computer as well. Okay, Putin, so in morning session I will be taking some computer related questions also, so that you can practice the questions of computer, and computer is also coming in tier 2 exam of CGL. So definitely we will be bringing some exclusive sessions for the computer as well, and then we will be doing some generic questions in the morning and special session in the evening shift. So point is noted. So I hope my dear it is clear कि on what condition acting Chief Justice is appointed by President. Is it clear to all of you? Is it clear to all of you guys? Okay. So correct answer will be guys option D, and Prime Minister has nothing to do with the appointment in the judiciary. Chief Justice plus Law Minister has nothing to do with the appointment of the acting Chief Justice or temporary Chief Justice. Now let's come to the next question. In which of the following cases Supreme Court of India enunciated the doctrine of basic structure? So doctrine of basic structure, it was defined in which of the following cases of Supreme Court? Easy question for all of you. So easy question for all of you. Okay, what the doctrine of basic structure that was given in which case? Is it Golaknath, A.K. Gopalan, Keshwananda Bharati, Menka Gandhi? Very easy question for all of you guys, and those who have read the things properly, they must be knowing about the doctrine of basic structure. Okay, let's see. Students, they are showing option C, Vikramaditya, Putin, all are going with option C. And basic structure is that structure on which the constitution is standing. So it is the base of the Constitution of India. Base of the constitution. And although what is basic structure, it is not defined. What is basic structure? It is not defined in Constitution of India. It is not defined in the Constitution of India कि what exactly the basic structure is. So whatever it is not written in the Constitution, the duty is of Supreme Court to define those things. So Supreme Court in the Keshwananda Bharati versus State of Kerala case 1973 gave the doctrine of the basic structure, and in this Supreme Court said कि Parliament has power to amend any part of Constitution without changing the basic structure. Without changing the basic structure. So correct answer will be Keshwananda Bharati versus State of Kerala case. Now in Golaknath versus State of Punjab, Supreme Court simply said कि Parliament can't amend the fundamental rights. So Parliament can't amend the fundamental rights. So fundamental rights can't be amended by Parliament. So that was written in Golaknath versus State of Punjab case. Keshwanand Bharati 13 judges bench, Golaknath 11 judges bench. So doctrine of basic structure that is defined in Keshwanand Bharati case. And in Golaknath versus State of Punjab, simply Supreme Court said that Parliament do not have power to amend the fundamental rights. So correct answer will be what? It will be option C. Now we will be moving to the next question to discuss what next question is. Okay, now this is a question, very good question, कि power to enlarge the jurisdiction of the Supreme Court of India with respect of any matter included in the union list of legislative power rest with President of India, Chief Justice of India, Parliament of India or Union Ministry of Law, Justice and Company Affairs. So who has power to increase the jurisdiction of the Supreme Court? So which authority has power to increase the jurisdiction of the Supreme Court? Which authority has the power, guys? Which authority has the power to increase the jurisdiction of the Supreme Court? So let's see the correct answer. Power to increase the jurisdiction of the Supreme Court, it is given to the Parliament of India. So Parliament of India can increase or decrease the number of judges in the Supreme Court and also can increase the jurisdiction of the Supreme Court. So enlarge means increase and has power to increase or decrease the number of judges in Supreme Court also. So it has power to increase or decrease the number of judges and also to increase the jurisdiction or decrease the jurisdiction of Supreme Court. Right now, number of judges working is 29 and the sanction strength is 34. So number of judges working is 29 and sanction strength is 34. So correct answer will be what, guys? It will be the Parliament of India. So Parliament of India can increase the judges, decrease the judges. Presently they are working 29. Presently, guys. And the sanction strength is 34. So sanction strength that is did by Parliament, it is 34, and that both number includes the Chief Justice. Both the number includes the Chief Justice, so it is including Chief Justice of India. So correct answer will be option C, that is the Parliament of India can increase the number, also can increase the jurisdiction of the Supreme Court. And oath of the judges is conducted by President. Oath of the judges. Oath of the judges is conducted by the President of India. So correct answer will be option C. Now, so guys, I think this question is bit complex. It is consider the following statements about Supreme Court. Consider the following. So guys, it is a half written question and actually the question will be consider the following statement about President of India in respect of Supreme Court. So actually this is the half written question, so there must be some technical error. So the options is 1 only, 2 only, 3 only and 1 and 2. So this is the option, guys. So you have to consider the statement about President of India in respect of the Supreme Court. So now the question is fulfilled. So you have to consider these three statements with respect to the Supreme Court of India. One is if President takes the advice of the Supreme Court on its initiative on any matter of large public interest, if he seeks such advice only if the matter is related to the fundamental rights of the citizen. So which of the statement they are true? So in what condition President can take advice from the Supreme Court? Actually the question is, let me explain because it is half written, on what condition President can take advice from Supreme Court. So on what condition President can take advice from Supreme Court? So on what condition President can take advice from Supreme Court? Now this is the simplified form of this question. Now please answer it. So actually the question, it is misprinted, it is half written. Therefore I have explained the question so that it will come easy for you. So on what condition President can take the advice from the Supreme Court? This is the question. The first option is on its initiative on any matter related to the large public interest if he seeks such an advice on the matter related to the fundamental rights of the citizen. So what will be the correct answer? So maximum students, they are saying option D and option C. First of all guys, ki whatever the matter it is thought by the president on which he finds ki the Supreme Court advice can be a helping tool, then he can take the advice. So what will be the correct answer? My dear students, first of all, on the matter related to the fundamental rights of the citizen, President do not have to take the advice from the Supreme Court, because the person directly can approach to Supreme Court in case of hamper of fundamental rights. So in case of hamper of fundamental rights, the person directly approaches to Supreme Court. Next is on its initiative on a matter of large public interest. So public interest, that is nothing to do with the President of India. Correct answer will be option C, ki if he seeks such an advice. So if President of India wishes to take any advice from the Supreme Court, then he can take the advice of the Supreme Court. That should not be related to the public interest litigation, or that should not be related to any other thing. So on any matter, if the President of India wishes to take the advice of Supreme Court, he can do. So correct answer will be guys option. Correct answer will be guys option B. Correct answer will be option B. So correct answer will be guys option B, कि on any matter that is thought by the President of India, President can take directly the advice of Supreme Court. It is not like this कि for a particular matter President can take the advice. Now come to the next question, कि who has right to transfer any case anywhere in India. So which authority has power to transfer any case anywhere in India? Is it President, Supreme Court, High Court, or none of the above? So which authority has power to transfer any case anywhere in India? So that is the power vested with the Supreme Court of India. So the power to transfer the case anywhere in any place of India, that is did by the Supreme Court. So correct answer will be guys, that is the Supreme Court. So Supreme Court has power to transfer any case anywhere in India. So that you must have seen in the matter of Shashank Singh Rajput also. So they gave the petition that case should be transferred to the Patna High Court. Patna High Court in the case of Shashank Singh Rajput. But Supreme Court said that the Bombay High Court or the Mumbai High Court, they are also well enough to handle the investigation. So they did not transfer the case. Although the parents of Shashank Singh Rajput, the father of Shashank Singh Rajput, he said that because of the old age, I cannot travel regularly to Mumbai for the hearing. So please transfer the case to Patna High Court. So that was being did only by the Supreme Court of India. So Supreme Court can transfer the case. The recent it is the and the famous it is the case of Shashank Singh Rajput, and he was being, it is said that he was being motivated to commit the suicide. So that was attempt to commit the suicide. So correct answer will be guys option B, that is the Supreme Court. Now come to the next question. This is similar but a very different approach. The source of the basic structure theory of the Constitution in India is mentioned in Constitution, judicial interpretation, opinion of the jurist, or parliamentary statute. This is a bit high level question, although the language of the question is also very much sophisticated and the concept is also sophisticated. Although that I have discussed this question indirectly when we were discussing the doctrine of basic structure, what exactly the basic structure means. Okay, let's see the correct answer. Ki the theory of the basic structure of the constitution, it is mentioned where in India. So guys, it is not mentioned in the constitution of India. The theory of basic structure, it is not mentioned. And whatever it is not mentioned in the constitution, the work is of Supreme Court to interpret this. So opinion of the jurist means opinion of the judges. That does not depend upon the opinion of the judges. Other than this, it is not a parliamentary statute because it is related to the Constitution of India, and it is the judicial interpretation. So it is the judicial interpretation कि whatever the interpretation was given by the judges, and that was also through the majority, then it will be decided कि what is the basic structure. So correct answer will be option B guys, that is judicial interpretation. And judicial interpretation, the decision is taken through majority. The decision will be taken through majority. So correct answer will be guys option B. Correct answer will be option B, that means the decision which is taken through the majority. So correct answer will be option B. Okay, so correct answer will be guys, it is related to judicial interpretation. In judicial interpretation means ki interpretation that is given by the judiciary. It is called judicial interpretation, that is not on the opinion of the jurist. That means the person who has a deep knowledge of the law, they are called jurist. So I hope this type of question guys must have jolted your brains, and you must be able to understand ki what exactly the question is asking. Although some of the questions they are from the civil services also, CSE exam also, but they are not that much tough. Although you know the basic of the things, what is the language of the question. So if you can understand the language, then it will be very easy for you to answer it. Now guys, let's come to the next question, and before I should move to the next question, I will say everyone to please download this Exampur app. Why to download this Exampur app? Because in the app you will be getting the free job alerts so that you cannot miss any vacancy where you have the age and educational qualification. Next is the structured paid courses, and that is on affordable fee. So on affordable fee you will be getting the structured paid courses. Next you will be getting the free PDFs of the app session. So whatever the app session will be taken, the free PDFs will be provided to you so that you can do it, you can save it for your revisionary purpose. Next is unlimited quiz and practice for a better preparation of subject. Then you will be getting the current affairs. This is the most important segment of the any examination. Current affairs you will be getting on daily basis, on in app, weekly basis and monthly basis. That you will be getting bilingually in the form of PDF. Next you have the free previous year paper. So previous year paper you will be getting without any charge. Other than this, All India scholarship test to evaluate your preparation. To evaluate your preparation ki right now where you are standing, that is all given in this app, so that you can reevaluate yourself on the regular interval to check your compatibility with examination ki how prepared you are for the coming exam. Now guys, let's come to the next question. So this was all about our Exampur app and what features we are providing to you. That is all contained in this app ki whatever the exam oriented content is, that is all being given in this app free, and only the paid courses are there which is being paid, and but you have to give on the but these paid courses are also available on affordable fees. Now guys, come to the next question कि which of the following courts in India they are known as courts of record. So which of the following judicial system is called court of records? Is it High Court, Supreme Court, High Court and Supreme Court, or district courts? So which are called court of records? So which of the following is called guys court of records? High Court, Supreme Court, or High Courts and Supreme Court both, or the district court? So which are called court of records? What will be the correct answer guys? Court of records. Court of records, first of all you should know ki what exactly the court of record means. Court of record means two things. One is ki all decisions of the court is kept in writing and it can punish any individual for its contempt. Contempt means disrespect of the order of the court. And the court of records are two guys. One is the High Courts, they are also court of record, and the Supreme Court, they are also court of records. High Court, they are court of records through Article 215, and Supreme Court, they are the court of records through Article 129. So they are the court of record from Article 129. So correct answer will be option C. So correct answer will be option C, High Courts and Supreme Court. So 129 that is for the Supreme Court and 215 for the High Court. So correct answer will be option C. Now come to the next question guys. The next question is ki the pension of a retired judge of the High Court is charged on the. So if a person is retired from the judgeship of a High Court, from where that person will get the pension? So from where the judge will get the pension if he is retired from the High Court? Okay, let's see the correct answer. So the students, they are saying option A. So High Court judge, they retire at the age of 62 years and the salary of the judges is 2,25,000 and the salary of, this is the salary of the judges and the Chief Justice, it is 2,50,000 for High Courts. So once the salary, so salary comes from the consolidated fund of state, where that judge is working, and the pension comes from the consolidated fund of India. So the pension comes from consolidated fund of the India. So pension comes from the consolidated fund, salary comes from the consolidated fund of the state. And if I talk about Supreme Court judges, the salary of the judge is 2,50,000 and salary of Chief Justice of India, that is 2,80,000, and salary plus pension, it comes from the consolidated fund of India. That comes from the consolidated fund of India. So salary and pension, that comes from consolidated fund. For the Supreme Court and for the High Court, the pension of the judges, that comes from the consolidated fund of India. Contingency fund, guys, it is an emergency fund. So pension, it is not an emergency, so it is an emergency fund which is held by President, operated by Finance Secretary. So held by President, operated by Finance Secretary. So correct answer will be, guys, option A, that is the Consolidated Fund of India. So I hope, guys, this should be clear to all of you. And contingency fund, this is held by President, operated by Finance Secretary. Held by President and operated by Finance Secretary. Held by President, operated by Finance Secretary. What is the salary of district and session court judges? That depends upon state to state. So that depends upon state to state, Mr. Putin. So that is not fixed. That depends upon state to state, because the district and session court judges, they work under the state government. So the salary depends upon state to state. These both are the constitutional posts, so the salary is always fixed. So correct answer will be, guys, option A, that is the Consolidated Fund of India. So I hope, guys, this should be clear to all of you. Then I will be moving to the next question to discuss. Is it clear to everyone? Now, guys, come to the next question. Next question is ki consider the following statement regarding High Courts of India. First statement is ki there are 18 High Courts in the country. Mumbai High Court has maximum jurisdiction. No Union Territory of India has High Court of its own. The judges of the High Court holds the office till the age of 62. So which of the following statement is or are correct? So this type of question will definitely come in tier 2 examination, because these are all conceptual question which is based on the statements. Okay, what will be the correct answer, guys? Let's see the correct answer. So Sharvani is saying option D, Vikramaditya. Therefore, I was on the one side of the screen, so that before answering the question, you read the whole statements properly before answering the question. So you should go through the statements properly before answering the question. So the first statement is saying that there are 18 high courts in India. That is completely wrong. Today we have 25 high courts. So first option is wrong, guys. So this option gone. Then judges retire at the age of, then Mumbai High Court has the maximum jurisdiction. It is wrong. It is Guwahati High Court has the 4 state, Assam, Nagaland, majorum, that is A square NM. So Assam, Nagaland, Arunachal Pradesh and Mizoram. So the second statement is also wrong. So this wrong, this wrong. So this statement has also gone wrong. No union territory has its own high court. So this is also wrong because Jammu Kashmir plus Delhi, they are the UTs having own high courts. So this is wrong. So the first option ki judges of the high court, they retire at the age of 62. This is only correct. So correct answer will be option D. So these three statements has gone wrong. So correct answer will be only 4. So correct answer will be only 4 guys ki the judges of the high court holds the office till the age of 62 years. So this type of question guys, although very easy question in nature, it is not like that ki you have not read this thing before. Only the thing is ki you have to keep your mind open and you have to just use all the concepts that you have read simultaneously. So this is the beauty of this type of question ki you have to go through all the concepts simultaneously when you are solving this type of questions. So correct answer will be option D. Correct answer will be option D guys. So correct answer will be option D. Okay, come to the next question ki which of the following high courts has jurisdiction over more than one state or union territory? So which of the following high court they have the jurisdiction over more than one state? Over more than one state or union territory, Allahabad, Delhi, Gujarat or Maharashtra. Which of the following high court has jurisdiction over more than one state or union territory? Okay, let's see the correct answers. Okay, in guys there is Allahabad, that is only one, that is Uttar Pradesh. Now it is called Prayagraj. Delhi, only Delhi. Gujarat, we have only Gujarat, that is in Gandhinagar. Maharashtra, you have Goa, Maharashtra plus Daman and Diu plus Dadar and Nagar Haveli. Dadar and Nagar Haveli. So correct answer will be guys option D, that is Maharashtra. So that is Maharashtra, Goa, Maharashtra, Daman and Diu plus Dadar and Nagar Haveli, and their combined capital is Daman. Their combined capital is Daman. So correct answer will be guys option D, that is Maharashtra. So it has 2 state and 1 union territory. 2 state and 1 union territory, that is with the Maharashtra. So correct answer will be option D. Now Allahabad High Court is known as Prayagraj High Court, which is the 4th oldest High Court of India. 1866 this Prayagraj High Court was established. So correct answer will be option D. Now come to the question guys. This is a very beautiful question. And it's not that much easy, although you have read the concepts earlier, but just you have to apply the concept simultaneously. The scope of judicial review is limited in India. Indian constitution is a bag of borrowings. So use the correct answer through the given codes. A is for assertion and R is for reason. So first of all guys, try to solve this question. Read the question properly. I will be on the one side of the screen so that you can read the question properly and then give the answer. And this is a very beautiful question. Please read the question properly before answering it. Okay, Sitaram. So A is false, B is true. Okay, let's see the correct answer. Very good. So guys, really, that is A is that should be false. But R is true, A is true, but R is false. So now what will be the condition, guys? What will be the condition? So the option C is, just edit the option A is false but R is true, and D option is A is true but R is false. So now what will be the correct explanation? Please read the question properly before answering it. Please read the question. A should be false, R is true. So first of all guys, the correct answer will be option C. That is A is false but R is true. First of all, scope of judicial review, it is not limited in India. Judicial review, it is defined in Article 13 and it is adopted from USA. Adopted from USA. So it has been adopted from America. The Indian Constitution, it is a bag of the borrowings, it is correct. It is correct. It is the bag of the borrowings because many feature we have adopted from the constitution of different countries. Many provisions adopted from the constitution of other countries. So A is false but R is true. That will be the correct option. So correct will be option C. Correct will be option C guys, because it is not only judicial review, it is not only limited in India, it is adopted from America. So this judicial review, it is also applicable in America also. And Indian Constitution, it is a bag of borrowings. Reason is this ki many features of the Constitution we have adopted from the different countries. Therefore, A is true, false, but R is true. Correct answer will be option C. Now, which of the following writs examine the functioning of the subordinate court? Which of the following writs, guys, that examines the functioning of the subordinate court? Is it quo warranto, mandamus, certiorari, or habeas corpus? Okay guys, so this type of question may come in CGL tier 2, so be prepared for this type of questions. So be prepared for this type of questions also. So which of the following examines the functioning of the subordinate court? Okay, so Vikramaditya, option D, Sitaram, option A, Putin, option D. Okay, Sharvani Singh, option A. Okay guys, first of all, we are talking about the subordinate courts that is defined in part 6, article 233 to article 237. First of all guys, when we have discussed the writ, I have already told you that two writs, they are the judicial in nature. So out of the 5, 2 out of the 5 writs, they are judicial in nature. One, it is the prohibition, and second, it is certiorari. Prohibition, it is preventive writ in nature, which is issued by higher judiciary to transfer the case. So this is used to transfer the case. And certiorari, it is preventive plus curative writ in nature. So transfer the case and quash the order. Transfer the case plus quash the order. So correct answer will be, guys, certiorari. Quo warranto, legality of a claim on a public office. So quo warranto, guys, it is legality of claim on public office. Then mandamus is to command. This is used against the government authority. Habeas corpus, to present the body. It can be used against government plus private authority. So correct answer will be, guys, option C, that is certiorari. So certiorari writ it is issued. Certiorari writ it is issued. So first of all, guys, 5 writs are there. It is very easy to remember: habeas corpus, mandamus, prohibition, certiorari, quo warranto. Now how these writ functions, how this writ function, and the 2 writs are most confusing in nature. 2 of the writs, they are most confusing in nature. One, it is prohibition, and second, it is certiorari. Because it is preventive writ in nature to transfer the case. Certiorari, it is preventive plus curative. Transfer the case and quash the order. Fresh investigation it is did. Very typical type of writ is, guys, prohibition and certiorari. Prohibition means only preventive. That means if prohibition writ is issued before the judgment is given, and certiorari writ is issued after the judgment is given. So only the thing that you have to remember, ki on what condition what writ is issued. Prohibition means ki okay, stop, and certiorari means ki okay, just you stop and transfer the case to us. So in this, it is preventive in nature, and certiorari it is preventive plus curative in nature. So I hope, my dear students, please make always get your confusion clear about prohibition and certiorari, because the nature is very similar and only there is a minute difference between these 2 writs. Therefore maximum time the students they get confused. Maximum time the students they get confused, although they are very clear about quo warranto, mandamus, habeas corpus, but only they are confused with the prohibition and certiorari. So prohibition it is preventive, certiorari it is curative. I hope, my dear learners, is that clear to all of you? Okay. How many high courts in India they have the jurisdiction over more than one state or union? One state, union territory is not included. So how many high courts in India they have jurisdiction over more than one state? Union territories are not included. So this is the question. If you remember ki how many high courts are there in which you have the more than one state that is under jurisdiction, in which you don't have to include the union territories. Is it 2, 3, 5, 7? 2, 3, 5, 7. How many union territories are there? Then you have to count the things. Okay, very good. So Putin, Sitaram, they are saying option C, B, that is 3. Let's check. First of all, we have the Guwahati High Court, Assam, Arunachal, Meghalaya and Mizoram. So 1. Then you have Maharashtra or the Mumbai High Court, Maharashtra plus Goa. Then you have Chandigarh High Court, Punjab plus Haryana. So only we have 3. If Union Territory is not included. Union Territory is not included. So then we have only 3. Guwahati, Mumbai, Chandigarh. So maximum of you must have forget Chandigarh High Court. In Chandigarh we have also the High Court having the jurisdiction of Punjab and Haryana. So Punjab Haryana High Court, that is Chandigarh. Therefore correct answer will be option B. That means total we have 3 High Courts. Total we have 3 High Courts. Punjab and Haryana, Maharashtra, and Punjab High Court. How many times we will count Punjab and Haryana? That is the combined High Court. It is in Chandigarh. I hope guys this should be clear to all of you. Now guys, the next question is which among the following is not correct about High Court in India? The second appeal to the High Court is within the appellate jurisdiction. Every judge of the High Court is removed in the same manner as the judge of the Supreme Court is removed. Governor of the state appoints the judges of the High Court. High Courts may accept a petition that is related to public interest litigation. So which of the following guys is not correct about High Court in India? So what will be the correct answer? That is a very easy question guys. Ki governor of the state, they do not appoint the judge of the High Court. Judges of High Court, they are appointed by President. They are appointed by President. So correct answer will be option C. They are appointed by the President. They are not appointed by Governor. They are appointed by President. The highest court of appeal is the Supreme Court. Second highest court of appeal is the High Court. Second highest court of appeal, it is the High Court. Highest court of appeal, that is the Supreme Court. Okay. So correct answer will be C. So the judges of the High Court, they are appointed by President. Highest court of appeal, that is the Supreme Court, and the second highest court of appeal, that is the High Courts. Now guys, let's come to the last question. The age of the retirement of High Court judge is very simple question to answer. So the session will conclude with a very simple question. Okay, very easy question guys, that is option C. Retirement age of the judge of the High Court. (25) and retirement age of the judge of Supreme Court. So correct answer will be guys option C, that is the High Courts, and 65 it is the age of retirement of the judges of Supreme Court. So correct answer will be option C. Okay. So my dear students, so that is the wrong thing I have put. So guys, do not follow this schedule. So follow the schedule that was been given earlier. So students, with this we conclude the session of today, and I hope you must have enjoyed the session and found the session interesting and informative. So don't forget to like and share the video, as well as subscribe to our English medium prep by example. So these are very qualityful questions that may come in SSC CGL tier 2. So bye bye everyone. Let's meet again sharp at 11 AM tomorrow for a session on the mixed question series. So bye bye everyone, and let's meet again tomorrow sharp at 11 AM.